Hello, good morning, good afternoon, good evening, everyone. My name is Danielle Yao, the leader of Cyber Law and Governance at the Center for International Law at the National University of Singapore. It is indeed my immense pleasure to welcome our distinguished speakers and all participants from literally around the world who have joined us for today's discussion on the subject of legal accountability for malicious cyber operations. On behalf of the Center for International Law, the NUS, I would also like to acknowledge and express our delight and appreciation to the Oxford Institute of Technology and Justice, the Blavatnik School of Government, University of Oxford, for this collaboration. And in particular, of course, to our distinguished speakers, Professor Philippa Webb and Harriet Moynihan. Now, our dialogue today addressed one of the most pressing questions of our digital age. That is the question of legal accountability for malicious cyber operations. In recent years, we have witnessed cyber operations that have paralyzed government services, disrupted healthcare systems, and of course, electrical grids, leaving thousands without power in the depths of winter. That despite such escalating incidents, hostile actors do continue to operate with a troubling degree of impunity, or at least so in the eyes of the public. While the states have responded with diplomatic measures, such mechanisms are not entirely satisfactory as they do leave significant gaps in legal accountability. And indeed, while states have recently agreed to establish a new global mechanisms to advance responsible state behavior in cyberspace, it remains to be seen whether this process can lead to any meaningful outcomes in this direction. Now, quoting the words of Prime Minister of Canada, Mark Carney, we are in an age of rapture in the global world order. Now, how then can international law hold actors accountable when cyber operations cause significant harm to states, to critical infrastructure, and to civilian populations? Now, given that cyber operations can lead to effects which are just as devastating as kinetic attacks, why should the legal consequences be any different? And what stands in the way of achieving comparable accountability? So with this question, I look to our speakers today to help us unpack and to understand the legal options available, and more importantly, the challenges that need to be overcome. Professor Philippa Webb is a co-founder and the director of the Oxford Institute of Technology and Justice, and she's also the professor of public international law at the Blavatnik School of Government and a fellow of Exeter College in Oxford. Her research interests span all areas of public international law, with particular expertise in international dispute settlement, human rights, international humanitarian law, etc. And she does have extensive experience in international and national courts. Harriet is the head of accountability in international law at the Oxford Institute, and her work there looks at the application of international law to technology, including cyber operations, and of course, the buzzword now, artificial intelligence. She is also an associate fellow at the International Law Program at Chatham House and a research affiliate with the Oxford AI Governance Initiative of the Oxford Martin School at the University of Harriet. I would invite a University of Oxford, and I would invite the audience to refer to the full bio that we have available on the event flyer. To those online, just a quick note, there will be time allocated for the panelists to address your questions before the end of the webinar. There is a Q&A button. Please use the Q&A button to post your questions or indeed your comments as we go along. We do want to get back to you and to address some of these questions. So Philippa, if I may, let me first turn to you. Now, your institute has recently published a policy brief on legal accountability for malicious cyber operations. May I first invite you to share more about this document? What's the rationale? What's this address? We will pop the link to this document, to this paper in the chat link. Over to you, Philippa.
Thank you, Danielle, and it's really a pleasure to join this webinar, and we're honored to have such an international and expert audience. Let me first briefly introduce the Oxford Institute of Technology and Justice. So our mission is to harness the power of artificial intelligence to advance justice. And we have three pillars to our work. The first is access to justice, which is where we're using technology to expand access to justice for two groups, women and girls. We're starting off in Malawi, dealing with gender-based violence and child marriage, but also journalists at risk for being silenced just for doing their job. Our second pillar is the advancement of international law in AI-assisted court proceedings. And that's how we look at how you have a fair trial in the age of AI. On our website, which you can go to techandjustice.org, we have an AI Justice Atlas, where currently we're tracking the use and regulation of AI in 15 countries, including Singapore. And we're adding 40 more countries this year. And then the most relevant pillar for today is our accountability pillar, which Harriet heads up. And that is, as you said, looking at how we have accountability under international law for malicious cyber attacks. And we have another stream of work looking at the more effective use of digital evidence. But back to your question, Danielle, and we have a copy of the policy brief here. And if you come to Oxford, well, when you come to Oxford, we'll give you your hard copy. Harriet
Thank
led
you.
the work on that. And that brief examines how international law on the peaceful settlement of disputes, which is very well established and enshrined in the Charter, can play a role in the cyber context, and how courts, including international courts, can play a role in other ways, such as prosecution of cyber criminals. We've found in sort of scoping this area that the topic of the peaceful settlement of disputes is very under-researched in the cyber context. What has been said about it in the cyber context is quite high level. It's basically invoking Chapter 6 of the UN Charter and Article 33 within that, but not looking yet in a granular way at how those different methods of dispute settlement would apply in a cyber context, how you overcome some of the practical challenges of bringing a case. So that was the rationale for the policy brief, where we go into a deep dive into these methods and we test them against hypothetical cases to see that it's
Oh,
challenging. It's absolutely challenging, but there are some routes to accountability that may be available. The law on the peaceful settlement of disputes is a very fertile area for discussion because, of course, states have their differences, and we all very much have in mind Mark Carney's call for reimagining how we go forward in this current world of rupture. And states, of course, have differences when it comes to something as sensitive as the cyber context. But they have all agreed that the UN Charter applies, and that's where peaceful settlement of disputes finds a hook. And indeed, the peaceful settlement of disputes has been explicitly referenced in discussions on cyber at the United Nations, including the Open-Ended Working Group report from 2021. So that's why we're trying to find out what we can do in this area to enhance accountability.
thanks very much, Philippa, for that background. And it's a great read, isn't it? A really useful read. And I would certainly invite and encourage those online. If you haven't had a chance, use the link and have a look at the document. With that background, Harriet, can you elaborate a little bit more about this, what Philippa had mentioned, right? The obligation of states to settle disputes peacefully. You've looked at it, you've tested it against the granular hypotheticals. How may this be relevant in the cyber context?
Yes, thanks, Danielle, and thank you so much to the NUS Centre for International Law for hosting us, and to those of you who are joining online. It's interesting, as Philippa said, that there's been lack of focus on these legal measures, and we've seen a lot of political measures like naming and shaming, or operational measures like taking down cyber infrastructure, or financial measures like the imposition of cyber sanctions. And so what we want to do in this sort of research work stream is to think of where do legal measures fit into those. Is the peace and security framework a different one? Is that sort of looking at it differently, or can it sort of intersect with some of the things that are going on already, like the attributions that we're seeing? And to sort of really dive into the provisions of the Charter that Philippa mentioned, there's two in particular that are relevant in this context. First of all, there's Article 2.3 of the UN Charter. And I should say, of course, that at the UN discussion, it has been agreed by states that the UN Charter applies in cyberspace. So we're starting in this particular topic with quite a good base that it's not a particularly controversial area of international law. States have agreed that the UN Charter applies, and we might compare that to some other areas like international humanitarian law or sovereignty, where we're seeing much more controversy about what states think about the law and how it applies. So if we zoom into Article 2.3 of the Charter, and that provides that all member states are required to resolve their disputes only by peaceful means, which is an obligation of conduct. And then the other relevant provision of the Charter is Article 33, which provides that for disputes that endanger the maintenance of international peace and security, states have got a duty to seek a solution. So that's an obligation of result. And it's already been clear from the discussions in the UN that states acknowledge that many cyber operations today do pose a threat to international peace and security. Danielle, in her introduction, mentioned the intensification of effects of cyber operations, including on power grids. And only in December, we saw a very serious attempt to take down Poland's power grids in the middle of winter by, well, it was attributed by a private sector company to Sandworm, which is a part of the Russian military. So we're seeing these skirmishes between states that if that had been successful, would have had an extremely serious effect, and even the threat of it, which is enough under Article 33, because it's the potential to endanger the maintenance of peace and security, clearly is sort of relevant to these provisions of the UN Charter. And we've also seen situations such as in 2022, where Costa Rica was forced to declare a state of emergency as a result of a very serious ransomware attack, and the UK's GDP actually decreasing in value because of major cyber attacks here. So I think it's clear that these provisions are relevant. The question then is, if we're thinking about Article 33, what kind of means do states have to settle their disputes, and how do those apply in the cyber context? And as many who are listening in will know, Article 33.1 sets out a non-exhaustive list of the means that states can use, the peaceful means to seek a solution: negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, or other peaceful means of their own choice. And what our policy brief does is it goes through each of those means and considers just how they might apply in the cyber context and what's been going on already that might show that states are using these peaceful means to try to not so much formally settle disputes. We might think of it more broadly as trying to avert the escalation of situations which endanger peace and security. And it's clear that from Article 33, states have discretion about how they want to settle these disputes peacefully, about the means that they choose. I'd just like to pull out a couple from that list that are particularly relevant that we're already seeing. The first one is negotiation. If we think about the discussions in the UN that have been going on for over 20 years now, those are clearly a means of negotiation, a means by which states are trying to establish this framework on responsible state behavior in cyberspace that will build confidence building measures, capacity building measures, try to understand how international law applies, and of course, establish these cyber norms that were agreed in 2015 by the UN group of government experts. But we've also seen discussions at the regional level, including, of course, at ASEAN, the Organization of American States, and the EU, and some dialogue between the UN process and the regional agencies. For example, ASEAN adopting the UN cyber norms and coming up with a checklist on them. And then finally, I'd just like to flag up inquiry. If we think about fact finding, that's a very important step in any major cyber operation, to try and establish at the very outset who did it, who was the perpetrator. There have been attempts to try and set up international mechanisms for attribution, which haven't been successful so far. But you can see a push to try to develop the sort of techniques on attribution and consider the standards that apply, and including on evidence. And I think that's an area that also needs more attention, which we wanted to highlight as part of our research.
Thanks very much, Harriet. I think the last point that you touch on, attribution, I think has certainly be one that even among this audience, a number of questions that have come in advance of the webinar have actually focused on the question of attribution, what it means, how does it work, what are the challenges, what are the role of private actors in this regard. And perhaps I would like to leave some time and circle back to that very important question later. It is very interesting, I find, what you mentioned, and the paper talks about fact finding, because that's very also much linked to the question of attribution and the evidential challenges. Um,
Yeah.
Before we move on, could you elaborate a little bit more from your findings, in terms of fact finding, the push, the support, what are some of the issues that you have faced, what you have seen from your research on these fact-finding attempts vis-a-vis, this element of peace under the umbrella of peaceful settlement?
Absolutely. So there's three sort of elements to attribution, which are sort of the technical element of identifying who did it and what are their techniques and sources and procedures that they're using. There's the political sort of forms of attribution where, having identified the perpetrator, we see states trying to call out bad behavior, but often in concert with working with the private sector, as you say, Danielle. And we've seen more and more of this naming and shaming, not just by Western states and increasingly done collectively, but also now by states such as Singapore and China, calling out sort of malicious cyber operations. And then finally, we might think of legal attribution, where we have the ability of one state to identify that another state has carried out that attack, so that the behavior can be attributed to a state. And where there is also a violation of international law, then of course state responsibility is engaged. I think the really big developments we're seeing have been on the technical side. There's some interesting, I think, building of public-private partnerships and also computer emergency response teams developing around the world. So there have been some positive developments, and the UN points of contact directory is one of those, I think, because it's really seeking to strengthen this sort of cooperation between CERTs, as we might call them, computer emergency response teams. And so while we haven't, as I mentioned, managed to achieve an international mechanism for attribution where all states sort of cooperate together formally, there have been a lot of cooperation through commuter emergency response teams. There have also been situations where states come to the aid of other states in the face of a malicious cyber operations, smaller states that may not have attribution capabilities themselves. And we've seen interesting developments where, for example, Microsoft recently entered into a partnership with Europol to try and look at technical attribution and other issues. Cyber intelligence is being increasingly combined, and it can be quite powerful to have the intelligence of a state combined with the technical knowledge and cybersecurity knowledge of a private sector actor. And I think that that's positive because for a long time we've all been saying, oh, it's so difficult, this attribution. And it's true, cyber actors can hide their tracks very easily. But I think technology is also, I think it's actually the cooperation rather than technology that we're seeing these really important developments in cooperation. And I mean, I think the issue that's more tricky is we're seeing a trend, as I said, for more political attributions in public, which in many ways is good because it's really trying to reinforce the normative framework and say this is not responsible behavior. There is malicious activity taking place contrary to that framework. But there's a question around what standards of evidence are being used for those attributions, because typically the state that's accused will say, well, we don't agree with that evidence, that we deny this. And unfortunately, because cyber operations are usually covert, there's a situation where states are not prepared to make the evidence always public, and they will say they might be doing it to a high degree of confidence, but the standard is somewhat opaque. So there are
Yes.
issues, but there's certainly some interesting developing trends in this area, and keen to discuss. Yeah.
That's great. Thank you. Thank you, Harriet. And I certainly hope to have time that we can come back to that, especially, in terms of the private actor's role and the question of trust and which is the technology company that certain states may have more comfort with than others in terms of such intelligence sharing. So I think very interesting questions there. Now, you talked about legal attribution. So I want to turn to Philippa now for that. When we talk about legal attribution, and you spoke in the paper talks about disputes before international court. What is the potential for a cyber dispute before the international courts? And on what basis can such a claim be brought?
Thank you, Danielle. So I'm going to speak about this through mainly the lens of the International Court of Justice, which is both the court that I know best, but also the court that we examine in the policy brief in the context of hypothetical scenarios. So the first step is that the court would need to decide whether a dispute under international law arises in the case. So that's a kind of threshold question. And the court has, through a long line of jurisprudence, defined dispute as a disagreement on a point of law or fact, a conflict of legal views, or of interests between two persons, including states. And that is a very broad definition, and I think can, in principle, cover a dispute about a cyber attack. Now, the dispute, as that definition says, can be legal or factual. And as we've just been hearing in your exchange with Harriet, cyber disputes are often heavily factual, with a focus on the source of the operation through technical attribution. And as you've just been speaking about, that may be a joint activity to actually identify and solidify that technical attribution. So just to give you a real world example, in 2020, the United Kingdom accused Russia of hacking labs in the UK that were conducting research on COVID-19 vaccines. The Russian ambassador to the UK denied Russia's involvement. Now, that did not fit the definition of a dispute because the accusation from the UK did not allege that cyber activity constituted a violation of international law. But let's sort of take the hypothetical, like move this into a hypothetical. If the UK had expressly said this is a violation of international law through this cyber activity, which we attribute to Russia, that could form the basis for the dispute element to bring the case to the ICJ. Now, of course, and I'll come to this, you would need jurisdiction after defining the dispute, and that would be very challenging, especially in the case of Russia. But that first threshold requirement could be met. In practice, however, this can be quite tricky because states often remain silent in the face of statements of attribution about malicious cyber operations. So they don't have a clear statement where they deny it and invoke international law. But this is one area in which the jurisprudence of the ICJ has been developing. So right now, being heard before the court is the Gambia-Myanmar case, which is about allegations of a genocide against the Rohingya people by Myanmar, brought by Gambia on an erga omnes basis. So we're now hearing the merits of that case in the International Court of Justice. But in an earlier phase of that case, there was a challenge by Myanmar saying there's no dispute because we haven't had this express disagreement on a point of law or fact. And the ICJ in its preliminary objections judgment dealt with that argument and said that it did not require Myanmar to expressly oppose the claims of the Gambia, and that the test was actually that Myanmar had failed to reply to Gambia's claims when a reply was called for. So in the words of the court, it may be inferred from this silence of Myanmar that it rejects those claims and therefore a dispute exists at the time of the application by the Gambia. Now, we should remember that there are various reasons why states may choose to remain silent in the face of allegations of illegal cyber activity. They might want to de-escalate the conflict. They might not have diplomatic relations with the state, so they don't want to engage in diplomatic exchanges, or they lack a functioning government, so there's not actually someone authorized to speak on behalf of the state. But the ICJ's case law coming out of this Gambia-Myanmar case does suggest that if a allegation calls for a reply, then silence could indeed be construed as a denial, satisfying the dispute requirement. So that threshold, we see ways in which that threshold requirement could be overcome. Of course, as I already flagged, we then have the challenge of jurisdiction. The ICJ does not have mandatory jurisdiction despite its statute being annexed to the UN Charter and all states in principle being members of the court. We still have to find consent in every single case. So that may be under a compromissory clause of a treaty, and we explore in the policy brief potential treaties that could have that effect. It could be a special agreement between the states, and that's in particular if the respondent state wants a legal decision clearing its name. Or it could come under the so-called optional clause to the ICJ's jurisdiction, Article 36. There are 74 states that have made declarations under the optional clause, thereby accepting in advance the court's jurisdiction. However, the majority of those declarations have reservations attached to them that narrow down their scope. I actually, before this session, did a quick search of those declarations to see if there were any cyber exclusions, and there were not. So cyber has not been expressly excluded by any state, but there's a lot of exclusions that may be involved, such as that anything that they want to resolve through separate negotiation or where it affects their domestic jurisdiction that could have exclusive effects.
Thanks. Thanks, Philippa, for that. It's very useful, and also that recent, more granular look at the
I
reservations
know I had
and
to
what is
open
excluded.
declaration by declaration because they're not actually in full text.
But that's not surprising. I mean, cyber really wasn't something that was a
Yeah.
real, incident in at the time.
Yeah.
So that's very helpful. Now looking at international courts, and Philippa spoke about that. I know Harriet, you spoke about it a little bit earlier, but do you think they are ready for such cyber cases? And you talked about the complex technical evidence. Can those practical challenges be addressed? And linked to that, really, when we talked about smaller states, what kind of support, and I'm not sure whether your paper looked at that, but what kind of international support could help kind of level the playing field for, smaller states, in terms of the practical barriers that are faced, particularly, things like cost, evidence, political pressure, even.
Yeah. Why don't I start off on that? So
Sure.
first, I would just say on a positive note that the ICJ is more dynamic than ever. It is busier than ever in its 8 decades. And it's had an influx of new judges in the last round of elections and hopefully in the elections to come this year, who are very technically adept and also, uh, I think, bringing a real granular approach to fact finding and evidence in the court. So the court is actually dealing with very, not cyber cases, but very fact heavy cases. There's the Gambia Myanmar case that I mentioned that's going on right now. But we also had the climate change proceedings that were decided last year and were heard the year before, where you had 92 participants in the advisory proceedings, and there was very heavy scientific evidence, including on tricky attribution issues. And the court dealt with that and it didn't shy away from it. And it even controversially, to some extent, called in experts that it met with privately to really increase its understanding of climate science. So I think this is not the court of 10, 20, 30 years ago. This is a court that has potential to deal with complex technical evidence. The challenge with the cyber context is that the evidence involved in these cases may be sensitive for national security reasons. And it's very understandable that states may be reluctant to provide that evidence if they're not reassured by the court's procedures that this will be dealt with properly. The ICJ's rules of court don't have provisions to protect sensitive evidence as such. They do have provisions on redactions and in-camera evidence, but not specifically on national security evidence. But again, I think I see potential for development here. Just in September last year, the European Court of Human Rights amended its rules to adopt rules that provide for the handling of sensitive evidence. That's Rule 44F of the European Court's Rules of Court. So that could be at least a starting point for the ICJ
Mm.
to look at. And I know that the judges do engage in intercourt dialogue, including with the European Court. But even without that rule in place, the court already has procedures in its statute that could be very useful in a cyber case. So the court has the power to protect the identity of witnesses. As I said, it has the power to hear evidence in a closed courtroom. It has the power to appoint its own expert witnesses who advise the court. It also has the ability to hear expert witnesses brought by the parties and to have an examination and cross-examination process. The court, of course, has the ability to hear oral evidence, and sometimes digital evidence can come up in that. So in the South Africa Israel case, open source digital evidence was presented to the court, including satellite imagery and videos of the situation in Gaza. And the court may also be able to rely on fact finding by other commissions or courts. So in the Bosnia-Serbia case, which is now nearly 20 years ago, the court carefully examined the findings of the International Tribunal for the former Yugoslavia, which is, of course, dealing with individual criminal responsibility, but it adopted the facts and certain judgments of the ICTY in its own reasoning. And right now in the Gambia-Myanmar proceedings, the court is looking very carefully at the UN fact-finding mission's report. So it could be if there's already something out there, and this goes back to the idea of, how can private actors play a role or, other entities play a role in attribution, that the court may be able to take note of that and give it a certain weight.
Thanks very much, Philippa, for that reminder. It's a question of how the international system as a whole ought to work together, systemically, and which was, in fact, the term in the climate change advisory opinion, systemic integration. And in this case, in a way, how do we use tools we already have? And I think that's calls for a lot of creative thinking. Harriet, I want to come back to you. I don't want to taking full advantage of your presence here. Now, we've talked a lot about the international arena. Let's move a little bit to criminal prosecutions.
Sure.
Courts have a role, domestic, regional, whatever. But how far have they been effective in securing accountability for malicious cyber operations? Because these will be against individuals. And where does this new UN Cybercrime Convention come in? Does it make a difference?
Yeah, sure. Thanks, Danielle. And I think this is a really important topic because, as we've acknowledged, attribution is difficult. To attribute a malicious cyber operation to a state can be hard. And that's increasingly the case where states are using proxy actors. Like it might be civilian hackers or it might be a kind of criminal gang. We've certainly seen this in the Russia-Ukraine conflict. But the states concerned are deliberately using actors that are sort of sufficiently distant to them that they're sort of sponsored or sanctioned but not controlled. So they won't be caught under the quite high thresholds that are set out in the articles on state responsibility. So the move towards a sort of criminal prosecution and actually trying to sort of get accountability through action against the individual rather than the state is really important here. And I think it's fair to say that to date there haven't been that many prosecutions of cyber criminals compared to the sort of vast ecosystem of cybercrime around the world. And of course, as I've mentioned, a couple of the challenges that are involved because cyber operations are such that they're covert and the perpetrators will try and hide their tracks through VPNs or spoofing. And then even if you can identify the perpetrator, then they may well be in a jurisdiction that is not prepared to extradite them for trial. So there've been a few barriers there, but I wanted to highlight a few sort of trends, perhaps in the more positive direction that we're seeing in this space. I've already mentioned public-private partnerships that have helped with technical attribution, but also the fact that states are working together more on this. So, for example, in the ransomware context, we've seen the counter-ransomware initiative set up with, I think, a number of states who are not only helping to work together on prosecutions, but also thinking about connections and cooperation that will help extradition. So if we have a state that's part of that initiative, and then, for example, the US decides to issue an indictment, then that allied state may well be able to then extradite to the US. And we've seen a number of extraditions taking place, which means that the cyber criminals that are indicted are then restricted in their travel movement. So it's already a disruptive measure, even if the prosecution itself doesn't happen. Then we're also seeing, in response to these very complex cybercrime operations, what I call a multi-agency approach. And we talk about this in the policy brief, where it's not just states and it's not even just private sector. It's also these intergovernmental organizations like Europol and Interpol, all working kind of as one in a network to try and take down really quite major operations that are across the globe. Because, of course, that's another challenge of these cyber operations, that there are multiple jurisdictions are involved and they're moving at speed. And there are a couple of big operations that have been spearheaded between, I think, the US and Europol in particular, which have seen major takedowns of infrastructure, but also the role of courts and the law is critical to that. So one of them is Operation Endgame, which saw lots of cyber infrastructure being taken down and arrests through Interpol, but also Operation Kronos, which was led to the takedown of the Lockbit ransomware infrastructure, which was pretty much the biggest ransomware operation around the world. And it was very effective. It wasn't just the takedown of the infrastructure, but in parallel to that, the arrest of the perpetrators and the imposition of sanctions. So there you're seeing a sort of multi-pronged approach, which lots of different measures being used in tandem. But the court's being relevant in two ways there. First of all, as in the form of indictments, so to try to prosecute those who've been taken in, but also civil cases being brought for warrants to actually take down the infrastructure. So we're seeing a sort of both criminal and civil use of the courts there. Now, Danielle, you mentioned new treaties that are emerging in the relation to cybercrime, and those have also got an important role to play. Of course, we have the UN Convention Against Cybercrime now, signed just in October, not yet in force, but we suspect it shall be, in due course. And we've already got the Budapest Convention on Cybercrime back from 2001, which has got 81 states parties, including the US, and is already used quite effectively to try to kind of speed up cooperation on electronic evidence. Because obviously the sort of traditional neutral legal assistance system is notoriously quite slow and cumbersome. And in the cyber world, things are moving at lightning speed. So to have new procedures that enable the gathering of electronic evidence across borders is very necessary. I just wanted to flag a couple of other treaties that are coming on board that are important in this space. The second additional protocol to the Budapest Convention on enhanced cooperation and disclosure of electronic evidence has been signed, but also not yet enforced. But that, like the EU's new e-evidence framework that is coming into force this year, will enable states to go directly to private sector providers, for example, for things like subscriber data. And that's going to obviously speed things up, because rather than having to go through the state-to-state procedure, states can go directly to the private sector. So I think it would be very good if states can sign up to these treaties. Obviously, there have been concerns about the UN Cybercrime Convention from a human rights perspective, but I think many states feel that there are provisions in there that now do directly address the human rights issue, and there's an obligation to implement those provisions in accordance with international human rights law. Perhaps my final point on these new treaties is that even if they are not currently enforced, some of them, they will be important for states to upskill in this area, to invest. In order to actually sign up to them, you need to be able to put on your books as a state these cybercrime legislation. You need to be able to have the ability to cooperate, for example, set up a unit that will be prepared to liaison requests for evidence and vice versa. So I think it's really encouraging to see that the states are thinking about these issues, but there is, as ever, a capacity building necessity here, that there's need for work to do on that, and not all states will be able to just carry out these activities easily. So I think it's sort of thinking about where there can be capacity building and how other states can help with that.
Thanks very much, Harriet. I mean, it's a very useful sort of roadmap, if you could put it that way. What your last comments in terms of it's not just having a convention. how do you operationalize that? And that can be quite tricky because without that, competency, without that framework, without that legislation, that enabling framework, even on the domestic level, there's only so much a piece of paper that a convention can actually do. And the role, of private actors, the ability to go straight to private actors. I guess it's a pro and a con. For some states, it may actually be a inhibiting factor rather than an encouraging factor. And I certainly encourage those online. There are a number of them who are actually representatives from states, legal advisors, foreign diplomats. Certainly would encourage you to, add your views on this, innovation, so to speak. Some would welcome it, but some actually look at it with a level of hesitation, I would say. So more to that later, and let's have encourage a dialogue with the audience who are here. Before I move on, Harriet, I can't not ask this question about the International Criminal Court. They've recently published a policy on cyber-enabled crimes under the
You
Rome
also have
Statute.
this as a prop.
There we go. So what kind of cases do you think we might see
Harriet
the Office
Library
of the
building up.
Prosecutor bringing in this area? That book, that publication that Philippa has just flashed, and I'm sure there's interest. Do you see a role for the ICC?
Absolutely, I do. Yes. I mean, I think that there's been, as we know, as many of you listening will know, there's been many discussions about how international law applies in the cyber context. But there's really been a gap when it comes to international criminal law. I think only one state has actually included international criminal law in its national position. That's Austria. And we've talked about the importance of prosecution of individuals, including because of the difficulty of attributing behavior to states where it's often state-sponsored. And of course, international criminal law focuses on individuals. And sadly, the level of intensity and seriousness of cyber attacks, it's now perfectly possible to conceive of cyber operations that reach the level of an international crime, particularly in armed conflict, but also outside it. And I think what's very good about this new policy by the International Criminal Court is it shows that international criminal law is technology neutral and that it can be adapted and there isn't some kind of legal vacuum. And I really endorse it because it's a very clearly set out document. And it kind of makes clear that already the International Criminal Court is looking at the prosecution of cyber-enabled international crimes in some of the situations it's looking at, but that often that will be in the context of a kinetic action, so that we're seeing cyber operations that often facilitate kinetic action. They might be, for example, online surveillance that's used to guide strikes that are contrary to international humanitarian law and can reach the level of a war crime because they, for example, target civilians. Now, it's true that, as we've been discussing, prosecution of cyber operations is difficult. It's hard to get the evidence, etc. But there are some crimes that are mentioned in this new policy that are perhaps easier and a bit more straightforward to look at. And I just wanted to flag offences against the administration of justice, which is Article 70 of the Rome Statute, that are perpetrated or facilitated by cyber means. And one example that's alluded to in this policy is tampering of evidence, and that could include through the use of deepfakes. And as we know, deepfakes is an increasing problem at the moment, and it's really tricky because the technology to detect them is struggling to keep up with the ability of those who are creating deepfakes to really make them sort of evade this technology. But it's simple to say that if there is a deepfake established as part of evidence, then that may well cross the boundary of offence against the administration of justice. So that's just one small example of how you can see this policy sort of gaining traction and actually having a very practical application. When it comes to sort of major cyber operations, that may be more difficult, and that's where the multi-agency approach that I mentioned before is likely to be relevant. But you would have the International Criminal Court involved with Europol and with other states to try to get the evidence concerned. I can't resist the opportunity to flag a Chatham House paper that's come out this week.
I don't have it.
Unfortunately, I don't have a hard copy available at the moment, but I can put it online. And the reason I mention that is apart from the shameless plug, is because it talks about the importance of the policy, not just from the point of view of the International Criminal Court, but also for national courts. There are some states today that have already prosecuted cyber-enabled international crimes. If we think about the prosecution of the war crime of outrages against personal dignity through, for example, foreign fighters taking photos on their smartphone of mutilated bodies and disseminating them around the internet. In Finland and Sweden and the Netherlands, we've seen those kind of cases already successfully prosecuted. And I think states need to be thinking about how they might prosecute cyber-enabled international crimes. Do they have the legislation necessary to do that, or to participate in joint investigations to do that? And how can they work to support the International Criminal Court in its investigations?
That's certainly a very new area to look at, a very exciting area as well. And I'm sure there'll be lots of thinking. And certainly, if I could appreciate you popping the link into the chat for all the participants, we'll definitely draw more attention and traffic to this very recent paper, which I've had a chance to glance through, but not thoroughly in time for the session today. Before I move on, and just one, I was just checking through the Q&A. So let me just encourage others to post any additional questions you
Danielle,
have.
I also realize I didn't answer specifically your question on smaller states before the
Yes, that's
ICJ.
right.
So I could just say a couple
Yes.
of points on
Please
that.
do. Please do.
So actually, the ICJ is a very welcoming venue to smaller states because it, unlike an arbitration, like if you have an ad hoc arbitration, um, the judges are already identified and in place, so you're not having that battle as it can be back and forth between smaller and bigger states over who's appointed to the panel. It's also already paid for in a sense that the cost of the ICJ in terms of the court and the registry's fees is part of contributions to the UN in the UN budget. So you don't, unlike with an arbitration again, or some ad hoc commission, there isn't an additional cost on top of that. The other thing is that through recent advisory opinions in particular, there's been a real growth in the number of counsel and the variety of counsel appearing before the International Court, which is a wonderful development. A lot of younger, up and coming counsel. So it's not just all the usual suspects, and it's very geographically diverse, which means that there could be ICJ experienced counsel from the relevant state or region already ready to go. And anecdotally, these counsel are, working for quite low or even pro bono rates often in cases. Not to say that that would always be the case, but it's more of a theme before the ICJ than I think before other courts. There is also a sort of hardship fund for the ICJ, which states can apply for to help offset their costs before the court. So that's already in place as a trust fund managed by the UN. So all of those factors mean it's actually quite a good venue for smaller states to bring their cases.
Thanks very much, Pippa. I want to just close off with a question, and incidentally, you're talking about the ICJ. Now, certainly, the law is quite unsettled in this area. The different positions on issues like sovereignty. If you look at the national statements on the application of international law, the SPIBA says, and there are also, at least within the OEWG context, there were even questions about, the applicability of IHL to cyber operations. So in this sort of a landscape, apart from, I would say, litigation between two parties, do you see any possibility of a request for advisory opinion? You see this trend in other areas? And if there is such a possibility, what kind of specific legal questions do you think would be most impactful for an advisory opinion, court to address in this context?
I think Yeah, that's a great question and very timely given the growth in advisory opinions. I might just give a sort of general response and then leave the specific drafting wording to Harriet, who has thought about this. So, uh, as I was saying, advisory opinions are having a renaissance at the ICJ, and they're also dealing with big, fact-heavy existential issues. So climate change is an example of that, and the 92 participants before the court in those proceedings. But advisory opinions on climate have also come before the Tribunal for the Law of the Sea, the Inter-American Court twice, and the African Court of Human and People's Rights, which is pending. So it's not just the ICJ where advisory opinions could
Yeah,
be relevant.
indeed.
But if we focus on the ICJ for a moment, it's the organs of the UN and 16 specialized agencies who are authorized to request advisory opinions. If it's a specialized agency that requests it, it has to be within its mandate. So it has to be relevant to its mandate to request that opinion. But the most frequent requester before the court is the UN General Assembly, which is a plenary body and therefore can ask anything really that arises under the Charter, which this certainly would fit easily within. And in order to ask to make a request of the court, it requires the majority of member states in the UN General Assembly who are present and voting. In practice, that means you need to cross sort of the 90 state threshold because there will be absent or abstaining states. So I think it is like from a procedural point of view, very possible, but I'm going to hand over to Harriet on what they might ask.
Sure, thank you. I mean, there's some commonality in between the climate situation and the cyber one in that there's been a sort of degree of frustration building, I think, about the lack of progress on international law in the cyber context, especially
Absolutely.
perhaps with the final open-ended working group report last summer, where the references to international law were few and didn't really
Sadly
get
lacking. Yes.
yeah. So, in the same way that in the climate change space, there was some frustration that there needed to be a bit more clarity about what states' obligations were. And you could imagine in principle that a sort of quite generally worded request from, as Philippa says, perhaps the UN General Assembly on the obligations of states under international law with respect to cyber operations conducted against other states, including operations that may impact the sovereignty, territorial integrity, or political independence of a state, and perhaps asking, what are the legal consequences under international law for a state that engages in or knowingly allows or fails to prevent malicious cyber operations on its territory. So we can conceive of that, but I just also like to point out that we've obviously in the cyber context got this new global mechanism, and it's important that states really engage with that, and it may be premature to be thinking along these lines of advisory opinions, particularly as there are some key differences between the cyber and the climate context. And Danielle, I know you know both very well, but in the climate context for the advisory opinion for the ICJ. First of all, many states were in support of that. There was a real sort of, a coalition that was building. But also, probably most importantly, the court was mainly looking at treaty obligations there and really trying to interpret, okay, what are the obligations that need to be clarified around mitigation? And they could also look at the Conference of States Parties as a sort of means of interpretation of those treaty obligations. Whereas in the cyber context, obviously, we don't have a treaty in information security, at least. And it's sovereignty is a very slippery, vague concept, and I think many states would be quite nervous about the idea of the court opining at this stage, when many states are still trying to formulate national positions or probably updating them, and some haven't put out any at the moment. So I think we look forward to the UN Global Mechanism and really trying to sort of maximize the opportunities there, and in parallel proceedings or side meetings to discuss international law. But certainly advisory opinion is sort of in the wings if political frustration builds.
Thanks, Harriet, for that. I think step by step is a good way of going, and some would say it's been going step by step for 20 years now. So let's see, let's all be positive about the new global mechanism. It's starting this year. I think the procedural meetings will be taking place fairly soon. And so let's hope that all parties will be able to, make full use and, as you say, fully engage in this global mechanism and take this forward. In terms of the questions from audience, I know we don't have much time, but I think a lot of the questions about attribution have been folded into the comments and responses already. There was one specific question here about, you know, is there any international legal implications of the ransomware cyber attack on UK Jaguar last year? I'm not sure if this is something that, perhaps Harriet or Philippa, you are able to comment on. And I also just wanted to, post two general comments and feel free to respond to them. And this is a question of a sovereignty dilemma, right? The policy brief and in the comments do already mention that major powers are often reluctant to frame cyber incidents as breaches of international law to maintain operational freedom. Now, this is a very powerful consideration. And my question is whether, how can this self-interest be kind of overcome in a quest for a consistent and enforceable legal framework? Is it realistic to expect the powerful, the cyber-enabled states to champion a system that could potentially be used against them? And the policy paper was released in September of last year. Couple of months into it now, if you're able to share any feedback or reactions from states, private actors, civil society to the contents of policy paper, especially the role of private actors, how can they come in? And I kind of alluded to this earlier somewhat about the trust deficit. And we saw this in the OEWG in terms of the vetoes that were put in place for the participation of certain technology companies from certain geopolitical spheres. Now, how does that play into your equation? So two very broad questions. Feel free to comment as you will as we close this very, very interesting and engaging session. I wish we had more time, but over to either of you or both.
I'm going to be very quick in framing and then hand over to Harriet, who's thought very deeply about these issues. The framing point is about, what's the incentive for certain states to get involved in this when, it could reveal sensitive information, it could inhibit their own operations, or they're just too big to care. And my sort of thought on that is that we know 130 states have suffered cyber incidents, many of which have targeted critical infrastructure or attempted to target critical infrastructure. So this is not a niche issue. This is a widespread issue, and it's only going to get worse. And one of the things, and Anthropic has a very interesting report on this, is the way in which AI is supercharging these attacks, in that it becomes easier and easier for people with relatively few resources, or states with relatively few resources, to conduct a very sophisticated cyber attack. So I'll just say that, states may now think they're too big to care, or that the balance of national security and accountability leans in favor of national security. But I think we're already in a landscape where ignoring accountability is not going to be sustainable.
Thanks, Philippa. Yeah, and I think
Harriet?
building on that, I mean, you mentioned a question about Jaguar Land Rover, which was a really, really, severe cyber attack on the UK that actually, as I say, had an impact on gross domestic product, put layoffs of workers for many months. It was the economic impact was very significant, and I think it underlines the severity now of cyber operations. I mean, there have been many human, I should say, victims as well, and even in that there have been sort of workers struggling, but I think it shows that cyber operations, we're not talking about petty cybercrime here. We're talking about implications for peace and security, especially where states are implicated, but we're not necessarily able to attribute to them. If we're seeing, which we increasingly are, this sort of blend or blurring of boundaries between cyber criminal gangs and states, then we're ending up in a situation where there's an escalation between states, but the victim state's not able to pin it on the perpetrator. So it's what are the means that we can use to try and sort of calm those disputes before we end up in a full-scale war. We're already in a hybrid war in many ways on this cyber front. And so especially, well, that's how it feels often in Europe, because we're seeing a lot of cyber operations which are no longer not just in the Ukraine, but as we saw in the example I mentioned in Poland, they're actually affecting major critical infrastructure across Europe. Just to sort of talk a bit about reactions to the policy brief, we would see this as very much the start of the conversation. We think there is much more to do. So, for example, the policy brief focuses on what states can do to respond to malicious cyber operations, legally particularly. But we're interested also about what non-state actors can do, whether that be individuals or companies, either through the courts or using law in other ways. The policy brief has been included in the cyber law toolkit, we're pleased to say. So I think it is gaining traction, and there's, I think, a lot more scope for discussion on peaceful settlement of disputes at the UN level as well, because I say it's not a controversial topic in itself, but very under-researched really in the cyber context. And perhaps finally, just to pick up on your point about trust, Danielle, and the role of private actors, I think there are many different ways in which trust can be built, because I agree that it is critical. Some of it is doing your due diligence as a state around what companies are and what, how they've been working. Some of them have got quite a well-proven track record in actually providing cybersecurity intelligence for the purposes of their own interests as well as states, but really wanting to work together with international organizations and international governmental organizations. Multi-stakeholder dialogue has a real role. And as long as some states exercise the veto to push out these private sector organizations, we can expect to see a lot more of this sort of parallel track of multi-stakeholder discussions, because I think many stakeholders in the cyber context recognize the critical role that the private sector does play. So we kind of have to have them in the room, at least in some discussions. And I hope that those discussions can complement what's going on at the UN to ensure that there's a more joined up approach.
Thank you very much for that, really excellent response and summation of the issues. I mean, we don't have much time left, but I just wanted to quickly briefly touch on what we talked about. We discussed the legal pathways that are available to states seeking legal accountability. This is perhaps the start of the conversation and the start of the engagement in this process. And while we have not yet seen a claim brought against another state in response to malicious cyber operations, we may well see a change as the understanding of international law as application to cyberspace matures and we deal with the jurisdictional, the evidential, the attribution challenges. Now, there's certainly two tracks, the state to state, and of course, the individual as a proxy to such actors. And we'll have to see whether, international courts at ICC, how will they play into this equation, and how are the existing and new cybercrime conventions aid and facilitate this process. We do see perhaps a growing appetite for cooperation in many forms, and not just prosecution, but takedown, operation, investigation. Let's see how that works, and even on a sanctions basis. There are, of course, challenges, attribution being one, and that's, I think, an area that probably needs a little bit more thought and a little bit more barriers to overcome, but there's been a lot of thinking in this area, and let's see how that can be overcome. Ultimately, the choice really is, do we have this continued impunity, or do we have a system that can impose meaningful constraints and meaningful accountability? Legal accountability is just one part of the entire toolbox, and they all need to work in tandem and with, I would say, deliberate coordination. So with that, I think it leaves me to again thank both of you for this really excellent, engaging discussion. I'll have a recording will be available at a later stage. I wanted to perhaps give Philippa and Harriet an opportunity also as our co-organizers for this event, if you'd have to say some closing words for our engagement today.
Just to thank you as well, and to thank all the very international audience. And we're seeing the little emoji expressions of appreciation, which we also appreciate. And to say that during this, Dr. Lam has been putting the links to the relevant reports in the chat. So please, if you want to learn more, read further, have a look at those.
Absolutely. Yeah, just to echo the thanks. It's been a really engaging discussion. And as I said, this is just really the beginning. We'll be hosting many events in Oxford and elsewhere on these themes. So we do hope you can all join us at those as well.
Thank you very much to both of you. Leaves me to only say good day, good night, wherever you are. And thank you for joining us. And I'll see you soon next week.
Yes.
Thank you.
Okay. Bye. Bye. Bye-bye. Bye, everyone.